Hi everyone, and welcome back to the All on the Line North Carolina Redistricting Leadership Program. All right, so here you can see the course outline. Today we are going to be talking about Stephenson v. Bartlett and the county groupings. So, Stephenson versus Bartlett and county groupings. First, we'll talk about why the Stephenson versus Bartlett case is important. We'll go into a little bit of the case background, and we'll talk about the redistricting criteria that came out of the case, and then we'll go on to the pièce de résistance, county groupings themselves. And then we'll end up with key takeaways, and I have another assignment for you. All right, so why is Stephenson versus Bartlett important? So, as you might know, litigation has always had a huge impact on how redistricting happens in North Carolina. If you've listened to our other lessons, you know that the state constitution doesn't have a lot of content about redistricting. It's not very specific. So whenever big legal cases get decided about redistricting in North Carolina, they have a huge impact on the process. Stephenson versus Bartlett is one of those cases. It fundamentally changed how we draw redistricting maps, and the principles that it created still apply today. In particular, Stephenson created the county grouping system, which is something that is unique to North Carolina. It doesn't happen in any other state, and it determines a lot about how our districts are drawn. So that's why we're talking about it today, is that it has this huge impact. All right, let's go into the case background. So, as you might remember from the state constitution, there is a part of the state constitution about redistricting that says no county shall be divided in the formation of a representative district. So districts have to be made up of whole counties, and this is usually called the whole county provision. So before 1980 in North Carolina, the norm was multi-member districts. So you would have a big district that would represent, that would have anywhere from 1 to up to 4 House representative, or 1 to up to 2 senators, depending on the population within that district, so proportional to the population in that district. And the reason we had these multi-member districts was because that's the only way that you could even get close to equal representation while keeping the counties whole, because our Constitution does say that you need to keep that you need to have equal representation, and so the only way you can do that while keeping counties whole is having these multi-member districts, because counties have different levels of population. So in the 80s, there were 2 very important cases that seemed like they were going to completely overturn whole counties, that it just wasn't going to apply anymore. The first of these cases was Gingles versus Thornburg. This is a very important case about the Voting Rights Act that we will talk about more, but with reference to the whole county provision, basically what was happening is that this case, the plaintiffs challenged the multi-member districts on the basis that they diluted the black vote and they didn't comply with the Voting Rights Act. So how that would work is, say you have this big district and you have a discrete black community in it, and the district votes for 4 representatives, right? And that black community might be the size that it could, if it was a single member district, have its own district and just vote for one of those. But the community is placed in this much larger district, and if the black community and white people don't vote for the same candidates, that black community is never going to have a representation or a representative that it chooses, because it's always going to be overwhelmed by the white vote. So that's what they're talking about when they're talking about the black vote being diluted. So in this case, the Supreme Court, the U.S. Supreme Court, decided that VRA districts have to be single-member districts, and that they don't need to comply with the whole county provision of our Constitution, because the whole county provision contradicts the Voting Rights Act, and federal law takes precedence. So after that case, the districts were redrawn, and they were redrawn without regard to the whole county provision in a lot of places. So then there was a second case called Cavanaugh versus Brock. So this case challenged those redrawn districts, alleging that the whole county provision should still apply to counties where there weren't VRA districts. So that the whole county provision doesn't apply to VRA districts, they conceded that, but that it should apply to everywhere else outside of that in the state. So the federal court that was involved in this case basically said the whole county provision has to stand or fall as a whole. So if it's invalid for VRA districts, it's invalid generally. So the whole county provision, according to the court, just shouldn't apply in general. And this was a federal court ruling on state law, and federal courts don't usually have jurisdiction over state law, but it was sort of considered to be the best legal interpretation at the time and the legal interpretation that people were going to act on. So, the 2000 redistricting. And, you'd say, okay, well, what about the 1990s? You talked about the 1980s, before the 1980s, what about the 1990s? So in the 1990s, the maps were drawn under the Cavanaugh interpretation, so under this interpretation that the whole county provision did no longer apply. So they were just drawn without whole counties. And those maps were challenged as partisan and racial gerrymanders, more or less only partially successfully. And the whole county provision was never mentioned in any of those challenges. So then 2000 rolls around, and in 2001, the maps were basically drawn under the same presumption that Cavanaugh applied and that the whole county provision wasn't a thing anymore. So that's how they do the districts. And here's a Senate plan that was drawn under that. However, the maps were immediately challenged in state court for violating the state constitution because they disregarded the whole county provision. And that case is Stephenson versus Bartlett. So here's just a little recap of the timeline of how the districts worked. So up until the 1960s, the whole county provision was in effect. We had multi-member districts, and equal population was not required by federal law, although there were attempts to kind of make things a bit more proportional within the multi-member districts. From the 60s into the 80s, the whole county provision was in place. We still had multi-member districts. And at this point, one person, one vote comes into effect, and so they have to try harder to make those multi-member districts equally representative. From the 1980s to 2000, after the Cavanaugh decision, the whole county provision doesn't apply. No more whole counties, and the districts are single-member districts, and they have equal population. And then in 2001, we get Stephenson v. Bartlett, which changes things again. So the whole county provision is back. That's the biggest thing that comes out of the Stephenson decision. The court basically immediately said that the Cavanaugh precedent didn't apply to the state. It's federal court. They had no business ruling on state law, and that the VRA districts were the only place where you could violate the whole county provision, and that it was still in effect in the rest of the state. So after more than 10 years, the whole county provision was just back. Okay. The Stephenson redistricting criteria. So the whole county provision aspect is probably the most notable aspect, but there were some redistricting criteria that came out of the Stephenson case, which are important because, like I said, we didn't have a whole lot in the Constitution. So if you remember, the state constitution only really has 3 criteria for state legislative districts. So there has to be equal representation to some degree. There has to be contiguity, so you can't have 2 sort of separate pieces of a district, or, 2 pieces of districts that are separated. They have to be connected somehow, and that the counties had to be kept whole. So the things that Stephenson added, the VRA districts have to be drawn first because they still don't have to comply with the whole county provision. All districts have to have equal population within plus or minus 5%. So the Constitution had always said that there should be equal representation, but there was no specific number, and now we have a specific number that has to be within plus or minus 5%. And this is applying to the state legislative districts. All the state legislative districts have to be single-member districts because if they have to comply with population within plus or minus 5%, they have to be single-member districts because multi-member districts wouldn't have that. And the districts have to respect communities of interest. Communities of interest is this big concept in redistricting that we will talk about more, but basically communities of interest can be things like political communities like cities, municipalities, it could be things like neighborhoods, it could be geographical areas, lots of different things. So the districts have to respect communities of interest. It wasn't a very specific standard, but it was in there. The districts have to be reasonably compact. So, these long, strung out, strange-shaped districts The Stephenson court didn't like stuff like that. It said that they have to be reasonably compact. Again, it did not give a specific number or a way of determining if a district was compact enough, but it did put compactness in there as a criteria. And then the Stephenson court also said that point contiguity is not enough. So if you have sort of two non-contiguous parts of a district, if they're just connected by a tiny point, that's not enough of a connection. There has to be a more substantial geographic connection. All right, so those are the criteria, redistricting criteria that came out of the Stephenson decision. And then we get to county groupings, which is really kind of the most significant aspect of the Stephenson case. So, what's the problem with county groupings? So I thought that this quote from a Law Review article put it really well. It is mathematically and demographically impossible to draw district plans that comply with the letter of the whole county provisions, so always keeping counties whole, the single-member district requirement, and the one person, one vote requirement. So you can't have whole counties that are single-member districts with equal population because counties don't have equal population. It's just impossible. So how do you solve this impossible problem? Well, the court recognized that you can't just apply the whole county provision as written. You can't just, whole counties themselves are not going to work now that you have this federal one person, one vote standard, and you've decided that you are going to only use single member districts, because something else that came out of the case is that the court decided that it's true that multi-member districts do cause vote dilution, and so they're unfair, and so we should have single member districts. So if you have single member districts and the whole county provision, those two things don't work together. And so the court acknowledged that. But it also said that the whole county provision has some good intentions and we shouldn't throw it out wholeheartedly. So what did the court do? The compromise that the court came up with was to create what we call county groupings. So basically, these county groupings, districts would be drawn within the county groupings, and the county line crossings within the groupings would be minimized as much as possible. So just saying that, I think, is not very helpful. County groupings are, not something I can just tell you about, so I'm going to try to show you. So how do you draw these county groupings? Well, the first thing you do is you find all the counties that have the right amount of population to have a whole number of districts drawn within them. And they are basically one county groupings. They're their own grouping. So Cumberland County is an example. Cumberland County has 4 House districts drawn within it. So Cumberland County is a grouping unto itself. And then you go through and you find all the groups of 2 counties that you can put together, that when you put those 2 counties together, they have enough for a whole number of districts. So this grouping has Franklin and Nash counties. So Franklin County doesn't have quite enough population to have its own district, and Nash has a little bit too much, so you pair those together and then you draw the districts within those groupings to get the right population. And then you move on to 3 counties. So once you've done all the 1 county groupings and the 2 county groupings, you move on to the 3 county groupings. So then you create a group of 3 counties. So this one that I'm showing you here contains Columbus, Pender, and Robeson counties. So, Pender doesn't have enough population to have its own district. Robeson has a little bit too much. Columbus is in the middle. You put all those 3 together and you draw the districts within them. And then you keep working your way up, 1 county, 2 county, 3 counties, until you get to things like this. This is a 7 county grouping containing Greene, Wayne, Sampson, Bladen, Johnston, Harnett, and Lee counties. And it looks like a monster, and no other state does this, and I think there's a reason for that, but here we are. All right, so what are the key takeaways from this? Stephenson versus Bartlett changed everything about how North Carolina draws its districts. We live in that Stephenson world. So it's a state court precedent, which means it could be overturned at some point, but it's definitely going to be in place in 2021. Also in 2021, the county groupings themselves are going to have to change. We can't use the same county groupings that we used in 2011 because the population have changed so much, right? And the population has changed unevenly. So lots of our cities have grown a lot, lots of our rural areas haven't grown much at all, and so that unevenness means that the county groupings are going to have to be different to make those compensations for population. Also, there's likely going to be not just one way to draw those county groupings. There will probably be multiple possible county grouping schemes that could be used. So there will be lots of different options. And this is important because county groupings can change elections. So the county groupings, you have to draw the districts within them. So the county groupings decide a lot about what districts you can even draw in the first place. And how districts are drawn changes the outcome of elections. We know that. You learned that when we talked about what redistricting gerrymandering are. Gerrymandering is how you use districts to change the outcomes of elections. And you do that by drawing the districts. County groupings restrict how you can draw the districts. So county groupings can change elections. That's why they're so important in North Carolina. And they're unique to North Carolina. They don't, no other state uses this system. And so it's something I think people forget about a lot of the time, but it is going to be fundamental in 2021. All right, so we're going to have a little assignment, and the assignment is going to be to find your county grouping. So you want to find your county grouping. You will have two. There's one for House and one for state Senate, and you'll find the ones that we have been using since 2011. Those are the current ones. And I would love to know, what is the county grouping that you live in, and do you think that the counties in your grouping make sense, right? So we saw that huge 7-county grouping, right? And I'm sure that the people in Bladen have feelings about being paired with Lee County or something like that. So, do you think that your county grouping makes sense to you from what you know about where you live? And the reason that I'm asking you to do this is because that will be a huge question in 2021. In 2021, there will probably be multiple ways that the county groupings can be drawn, and part of the Fair Maps fight will be making sure that the right county grouping scheme is picked, right? So because it has this huge effect, that is going to be a point on which we are going to have to fight for fair maps, is through the county groupings. And it's something that you won't learn elsewhere because it doesn't happen in other states, but it's something that kind of went by without a fight in 2011, and something that we don't want to let go by without a fight in 2021 because it is so important. All right, so that is Stephenson versus Bartlett and county groupings. Next time, we will be talking more about the Voting Rights Act, which we talked about a little bit here, and we've talked about in previous lessons, and the Gingles versus Thornburg case, which we definitely mentioned here, but it has a lot of implications beyond the whole county provision. So we'll be going into that for our next lesson. All right, thank you so much for joining me, and I will see you again soon. Take care, y'all.